Everybody all set? On the day that Colleen Ritzer's life was cruelly taken from her, the sentence for first-degree murder for a person over 14 without parole. 2 months later, on Christmas Eve, the Massachusetts Supreme Judicial Court redefined justice for this family and many others. In their Dyachenko decision, the Massachusetts SJC retroactively eliminated life without parole for juvenile murderers. This ruling went beyond the U.S. Supreme Court's Miller v. Alabama decision that stated that life without parole may not be automatically imposed upon a juvenile. In Miller, the U.S. Supreme Court allowed for individualized sentencing for juveniles. Our SJC has departed from that principle and has removed that discretion to impose an individualized sentence, even where the facts demonstrate, in the words of the Miller Court, irretrievable depravity. Oftentimes, when courts make decisions, the impact of those decisions can seem very remote and detached from our everyday lives. As we stand here today, I want everyone to see the impact of that decision. This family, who has suffered beyond measure, cannot close the book on this case. They cannot move forward with the knowledge that the person who took their precious daughter's life is not forever gone from their lives. Instead, they move forward knowing that at some point in time, they will sit at a parole board hearing, perhaps multiple times, and return to the most horrific and devastating event of their lives. As district attorney and a longtime board member of the Massachusetts Office of Victim Assistance, it is my duty, as well as my privilege, to advocate for victims of crime. An important way that is accomplished is to ensure that defendants are held accountable for their actions, and while nothing can restore their loss, a sense of justice is essential to the healing process for crime victims. Murder does not claim one victim. As we heard in the courtroom today, many people, family, friends, co-workers, students, and whole communities were victims of this murder. Murder tears at our sense of security and community. It violates our social contract in a fundamental way and leaves a hole that can never be filled. As Assistant District Attorney McDougall said, we took the defendant's age into account throughout the process and in our recommendation to the court. The evidence in this case is undeniable. The defendant acted deliberately, singularly, and maliciously before, during, and after the horrific events of that day. In closing, the defendant's actions were willful, deliberate, and cruel in taking the life, an innocent life, and should result in the permanent loss of liberty upon conviction. Before I let the Ritzers speak, I want to once more, because it's very important to me and to the criminal justice system in Essex County, point out Maureen Leal, Victim Witness Advocate Director and Superior Court ADA, Melissa Woodard, Assistant, that I can give them. Peggy?
We are devastated and feel betrayed with Judge Lowy's inability to give 3 consecutive life sentences without the eligibility of parole to the individual that took Colleen's life in such a horrific manner. We are disgusted and personally offended with the defense's repulsive recommendation that Colleen's killer be parole eligible within 15 years, therefore putting him back into society at age 29 to kill again. The defense's legal maneuvering is despicable and demonstrates utmost disrespect for our daughter and sister, Colleen's life. Evil cannot be rehabilitated. Today's sentence is unacceptable and the laws must be changed. Although we very much appreciate this court's commitment to seeking justice for Colleen, today's sentence did not achieve that goal. We recognize that Judge David Lowy was faced with a difficult decision, one that was unfairly restricted by the imprudent actions of the Massachusetts Supreme Judicial Court that decided juveniles who deliberately commit heinous crimes cannot be sentenced to life without parole. Colleen's family, friends, students, and those who admired her have been given a life sentence without parole, but not the individual who committed the heinous act. This is wrong and unjust. Today's sentencing does not conclude the legal process. The journey to ensure justice for Colleen has just begun. Because of the SJC restrictions, our family will be forced to attend parole hearings beginning in 38 years, which is simply unimaginable to us. We will have to relive that day with every hearing. As Tom and I age, Colleen's brother and sister, Dan and Laura, will assume this responsibility. However, we want to be very clear. At every parole hearing, our family's voice, Colleen's voice, will be heard.
Judges must have the discretion to impose a prudent sentence depending upon the circumstances. Based upon the testimony we heard in this case, we, and many others, believe that the juvenile mind is capable of distinguishing right from wrong. Each day, millions of juveniles go to school and learn and to be inspired, not with planned malicious intentions. The logic of the SJC is flawed and misguided. Therefore, judges must have the discretion to sentence juvenile offenders to life without parole, particularly in those cases such as this, during which undisputed and horrific evidence was presented. Although this individual parole amounts to cruel and unusual punishment for Colleen's loved ones, the notion of second chance should not be applicable in this case. Due to the intentional and thoroughly planned actions of this individual, Colleen cannot be provided a second chance, and neither should the individual who callously and without remorse took her life. The decision of the SJC is not only disrespectful to Colleen, but also to those who love her. The SJC's decision was a betrayal to all victims and their families. We are hopeful the governor and the legislature will recognize the great injustice imposed by the SJC and remedy this decision that extends rights to criminals and disregards the rights of victims and their families. While such an amended law will not provide justice for Colleen, it will protect future victims and their families. We pledge, as Colleen's loved ones, to apply the same vigor for life that Colleen demonstrated every day to righting this moral wrong.
The Ritzers are not going to take any questions at this time, and I ask that you respect that. They have been through what no family should go through emotionally for the last 2 years, and today was extremely difficult. I'll answer a couple questions before we conclude.
It sounds like, in your view, he deserved nothing less than life without parole.
The SJC, again, redefined justice for victims who thought they had closure in 2013. Certainly, given the facts of this case, which could not be more horrific, I believe somebody who commits murder in the first degree should not have parole eligibility.
If Chism is denied parole after serving the 40 years, how many times after that is he eligible again? In fact, how many times does his family have to go through this?
Every 5 years, someone can petition for parole there.
When they handed down the sentence, they said that he was being committed to DYS custody. Does that mean he's going back to the same facility where he allegedly attacked the other woman?
That's a question I'm not sure how they're going to handle that. I don't know. I know there's very few DYS facilities, so if he's going back there, that's not something I'm aware
So you
of.
just know he's in DYS custody, that's it? We don't
Until
know where.
21, correct.
Okay.
Yes.
Is there anything you guys plan on doing or can do to try to, you know, get what you guys want in terms of a longer sentence or not having parole, or are your hands tied at this point?
Well, the law is the law, as Mr. Ritzer said. I am sure there's going to be an extremely sincere effort to get to the governor, to the legislature, and the court can always change their opinions as they've done, as they have in the past. So this is just, you can't have a more horrific set of facts than this case bore out as evidence and a jury heard.
Did you say the SJC changed this law 2 months after the...
Miller v. Alabama. They changed the law again on December 24, 2013.
Okay.
Thank you.
Thank you. I have copies of the Ritzer statement.
Thank you.
That one,